Salutations, and welcome to another episode of Music Business After Dark. My late night vlog where I answer questions I've been asked over and over and over about the music business. My name's Jeff Lysyczyn. I've worked in the music business for over 2 decades, and I'm also an adjunct instructor at the Mike Curb College of Entertainment and Music Business at Belmont University in Nashville. Tonight, I answer the burning question, should I copyright my song? I don't know why it's always a hillbilly that asks me that. I want to try to unpack copyright for you, help you understand tonight what a copyright is, why you should get one, and why it's important to understand these laws a little bit. Oh, and to answer the question, the odds are you already have copyrighted your song. So let's dig into that. So there are some very famous copyright infringement cases throughout history. Recently, Katy Perry was sued by a Christian rapper by the name of Flame because he thought that her song Dark Horse sounded a little bit too much like his song Joyful Noise. Well, Katy Perry lost that lawsuit. A couple of years ago, Pharrell Williams, Robin Thicke, and the other writers of Blurred Lines were sued by the estate of the late Marvin Gaye because they thought that that song was too similar to one of Marvin Gaye's songs. They lost that lawsuit. I think both of those are in appeals, so the story continues. But even the Beatles were not immune to copyright infringement. The writers of the song by the Chiffons called He's So Fine sued George Harrison, saying that his song, My Sweet Lord, was just too similar. They won. I put links of mashups to all those examples I just gave you in the description below. Take a listen to them. See if you think the judges and juries got those cases right. Let me know in the comments what you think. You see, when someone sues another songwriter because they think their songs are too similar, in a court of law, they've got to prove 2 things. They've got to prove access, and they've got to prove similarity. So in other words, the accuser has to be able to show that the accused was able to get their hands on that song to hear it in the first place. And once they've been able to do that, then they have to prove that the 2 songs were similar enough to constitute copyright infringement, right? It's hard to steal something that you never even knew existed, right? But once you've proven that, then you've got to go through the process of showing how the songs are the same. And this is where the lines get, well, blurred. Because each side is going to parade into the courtroom musicologists and other experts. And on one side, they're going to compare these 2 songs and show how much the same they really are. And then the other side is going to parade in their own musicologists and show you just how not the same they are. But the kicker here is who they've got to prove that to. Because they're going to have to prove it to a judge or to a jury. And the odds are these people aren't musicians. Heck, they may not know anything about music at all. And that's who you've got to prove this similarity to. And there have been a lot of these lawsuits, more and more and more recently. And it's created a very slippery slope. Now, long ago, when I matriculated to Middle Tennessee State University, to study the music business, one of the first classes I took was copyright law, under the tutelage of the infamous Dr. Jeff Hull. Now, if I'm honest with you, I didn't really like the class. It was a semester of writing legal briefs and whatnot, and it was really dry. But once my career got started, I realized that the information I learned in that class was probably some of the most important information that I ever got in college. And Dr. Hull taught us in that class a very important two-word fact. And that two-word fact goes like this: copyright happens. And here's what he meant by that. You see, when people ask me, should I copyright my song? What they're really asking is likely, should I register my song with the Copyright Office in Washington, D.C.? To answer that question is maybe. More on that in a minute. But before I do that, let's explain copyright happens. You see, when you've written a song, you want to make sure no one can rip it off. That's what you're worried about, right? Now, I hope you've written a song so good that people will want to rip it off. That's a good thing. But there are two essential things that must be true for a copyright to be created. First, you must create an original work. That means you can't have borrowed any of the melody or any of the lyrics from someone else's song. Think about the sheer number of songs in the history of popular music in the last 100 years or so that have been written and released. It's really hard to arrange the 8 notes in any given key in such a way that it hadn't been done before. When you think about lyrics, there's only so many ways that you can say, I love you so much I could just die. So, it's tough, isn't it? But let's, for the sake of this discussion, assume that your work is deemed original. Well, congratulations. You are halfway to creating a copyright. Good for you. The second thing you must do is to fix that original work in a tangible medium. What the? Fix that work in a tangible medium. It's not as complicated as it sounds. That means that you've got to put that down in a way that can be reproduced. If it's lyrics, write the lyrics down on a piece of paper. Somebody else can read them. You could sing your song into the voice recorder on your phone. Now it can be played back. If you write music, well, get to slinging them dots on that staff paper. That's what you've got to do. You've got to fix that work in a tangible medium. And when you've done that, voila, copyright happened. And now you are the proud owner of a copyright. And under U.S. copyright law, you now have certain rights that are yours and yours alone. For example, only you can perform your song in public. Only you can record that song and distribute it. No one else can do those things without your permission. And there are a few other rights that you have when you are a copyright owner, but those are the really important ones. So if that's the case, and copyright just happens when I do those two things, what's the deal with spending $35 to register my song with the Copyright Office? Well, listen, think about this. Professional songwriters write a lot of songs, sometimes numbering in the hundreds of songs per year. Now, at $35 a pop, you can see where it gets pretty expensive to register their songs every time they write one. So many professional songwriters will wait to register their song until just before it's going to be released, whether they're releasing it on their own or another artist has recorded it, or whether it's going to appear in a television show. Right before that song gets released so the public can hear it, that's when a lot of them will go ahead and register the song with the Copyright Office. Okay? And here's why. You register your song to protect it. And until someone has the ability to hear it and therefore the ability to steal it, you don't really have that big of a need to protect it. So that's why it's okay to wait, right? Because no one can get their hands on your song until it's released. So it's okay to wait till almost that time to register your song. And when it's released, that's when it's absolutely necessary to register your song. And here's why. Unless your song is registered with the Copyright Office in Washington, D.C., you're unable to file a lawsuit for financial damages to someone who you think may have infringed or stolen that song. I'll recap that for you so you get a full understanding of it. It's okay to wait to register your song until around the time it's going to be released, because that's when people will have the ability to hear it and therefore the ability to steal it. So it's okay to wait. But when it's time for that song to be released, you definitely do want to register that song, because unless you do, you cannot sue someone for infringement. I hope that makes sense. So if you got a song getting ready to come out, get on your interweb machine, type up copyright.gov, and spend that $35. One last thing before I go. Those of you that might ask me, well, what about that thing where you put your song in an envelope and mail it to yourself and don't open it? Well, that's called a poor man's copyright. And that, I'm sorry, is not going to work for you. You see, according to the copyright laws, there's no provision for that poor man's copyright, and the courts don't consider that as a substitute for registration. So if your song's coming out, pony up the $35. Copyright.gov, register your song, protect yourself. Friends, copyright law can be a complicated and confusing thing, but I hope I've given you some knowledge you can use here tonight. And as always, I would really appreciate your support by subscribing to this channel, liking this video, commenting below and tell me what a quack I am. Send me an email, tell me about some other stuff you'd like for me to talk about down the road. And most of all, stay classy. Cheers.